Welcome. Thank you for joining us. This webinar is part of our HR in Half an Hour series. I'm Kristen White, the HR compliance consultant here at Morrison Garritano. With us today, we also have our marketing communications team as our technical experts. Plus, we have Angela Toomey, our internal HR director, who will jump in to answer your questions. So you'll see me most of the time, and then you'll see Angela pop in at the end of our questions. But feel free to post your questions in the Q&A feature throughout this presentation. The team will answer some of those directly in the Q&A during the webinar, plus we'll save some for the end. We are recording, so to everyone that registered, thank you. We'll send you an email with the link to this recording and the slide deck, plus we'll post them on our Morrison Garritano website. Okay. Our topic today is leave of absence. So if you came for LOA, you are in the right place. We're going to touch on the major federal and California leaves, FMLA, CFRA, PDL, plus I'll explain what all those acronyms mean. But disclaimer, we are not attorneys, and these are certainly not all of the leave types, but we're here to help. All right, let's start with the poll question. How confident are you in administering leave of absence? So basically, are you confident? Are you somewhat confident? Or you want us to send help? See what you get here. Regardless of your answer, though, you are in the right place. So if you're feeling fully confident, this should be a refresher. But if it's all new to you, then we are here to help. Okay, I see the results. 70% are winging it. So that's good. We'll take that. 21% are feeling confident. So not too many of you want me to send help, but so that's good. We're right in the middle there. Okay. Next up. So on this slide, you can see our lofty goals here with a purpose and objectives. My main goal is for you to gain at least an awareness of all the components, plus to understand there are different types of leave, which are separate from wage replacement options. So a lot of big terms there, and we'll break it down. And we'll provide links to several resources, especially for documentation. We'll cover several items with the goal of answering your frequently asked questions. I'm going to spend a minute here going through these because I want you to understand all the different things we're hoping to get through today. So a high-level process, what are all those terms and letters? Who is eligible for leave? And when can those different leave types be used? How do employees get paid? How do you coordinate all the different leaves? Are benefits continued while on leave? What happens when their protection ends? And importantly, what are all those documents and how do you get them? So now you can see the topics we're covering. You may want to hold some of your questions until we at least get to that section to see if I already addressed it. If not, then be sure to pop your question in the Q&A. So let's get started. Okay, what is the process? So these are the very high-level steps to keep in mind as you navigate managing a leave request. When you learn an employee may need time off, act right away. You may hear that the employee needs time off in a few months. Like maybe they're only a couple months pregnant, so they're not going to be out till later in the year. But you still want to go through these steps now. Start with asking questions to understand the reason they need to be out, estimate of their time frame, and then determine what they're eligible for. And make sure you inform the employee to set those expectations, inform them of how much time they get off, how they're going to pay for their benefit premiums, all those things. And lastly, the important step we hear bringing from HR folks is document, document, document. So that's certainly true for leaves. Now, these steps may not be one and done. Based on the employee's changing needs, you could need to start back at step one, and certainly the communication and documentation steps continue throughout the leave. What are the terms? So we throw around a bunch of letters. So here's a little slide for you can use as a reference key. An important takeaway is in that second table there on California. You can see there are two different types of leave under that employment protection. Then separately, two types of wage replacement. You'll hear the term protected leave. The protection mainly refers to their job plus health benefits. So that means you can continue health benefits while they're out, plus have a job available for them to return to. It needs to be the same job or what they call virtually identical positions, like same pay, hours, all those things. Now, since you can't give away their job, it's a common question we get, you have to either separate out those duties to other people, or you may have to bring in a temp because you have to have that available when they get back. Another poll question here. So which type of leaves does your company need to follow? Is it both FMLA and CFRA, only California CFRA leave, or you're not sure? Give you a moment here. Interesting. What do we get? Okay. Oh, so most of you are FMLA and CFRA. That's great. Okay. So we have both of those. A few in just CFRA and a couple where you're not sure. So any of those we're going to cover today. All right. So who is eligible for the leave? We're going to have a lot on this page, so we're going to try and piece it out. But this is a really important one and great first step. So first, determine what laws your company needs to follow. So what are you covered under? Almost all of you fall under those California leaves. Then the question for you to answer is, do you also need to follow federal, which most of you said you do. So that's if you have at least 50 employees. So now you know which bucket you need to follow as a company. Second step is determine if the employee is eligible under that bucket. So both FMLA and CFRA, you can see here, have employment requirements. And then FMLA also has a geographic requirement that CFRA does not. So one note on that, if the employee works from home, use their work site they report into as their work location, not just their home address. Third step, so lastly, determine the entitlement, which is just a way to say how much protected time off they get. FMLA and CFRA each 12 weeks. As a company, you have flexibility to determine the 12-month period, which you should document in your handbook policy. For ease of administration, companies often use calendar year. You could start at a different month. Just want to apply that to everybody. Another option is they call it rolling forward 12 months, rolling backwards. So you've got different options there. Now, PDL is up to 4 months, which equates to 17 1/3 weeks. So that's much longer. All of this is just to know which buckets you're dealing with, which makes a great starting point. When can each of those leaves be used? So now that you know which types of leaves the employee is eligible for, so next determine if their reason meets the requirement. Mouthful. So you can see there, pregnancy falls under both PDL and FMLA. Several reasons fall under both FMLA and CFRA. A note on that is you can see here in our second chart, when we pop that up, both FMLA and CFRA have caring for a family member as a reason. However, California has an expansive definition of what a qualified family member means, as you can see there on the slide. So that keeps growing. So I'm going to keep up on that. So if a leave falls under 2 types, they run concurrently, which just means you start the clock at the same time. Example, an employee on leave for their own serious health condition, the entitlement is up to 12 weeks total, which you count as both FMLA and CFRA. However, a leave for pregnancy disability only falls under FMLA and PDL, which means the employee still has up to 12 weeks of CFRA for baby bonding or another qualifying reason. All right, time for a third poll question. Are SDI and paid family leave considered leaves of absence? So this one actually has a right answer. So not just a poll we're asking, certainly. So it's either yes, no, or again, you're not sure. What do we get? I'm not seeing the results, but I'll still give you away the answer. So drum roll, the answer is no. These are not wage replacement benefits. I'm sorry, these are only wage replacement benefits. So these are not an actual leave. So we'll talk about this on our next slide. Okay. So how do employees get paid? Very common question. So far, we've talked about how much time employees can be out. However, regulations do not require you to pay employees while they're on leave. And there's some companies that choose to be generous and offer a payment. So that's where you'd want to check your company policies of what you've decided. However, California does offer partial wage replacement benefits. These are managed through the Employee Development Department, known as EDD, and are paid for through payroll taxes. So you can see on our screen here, we have state disability insurance, people know as SDI, which is when the employee is disabled, and that can go up to a year, but the protected time off doesn't necessarily go that long. And then you have paid family leave, a confusing term there because it's not really a leave, but when they're out for a family member is when this PFL would come into play. So family member, including bonding with a child. So that's why first, like on a pregnancy, you start with SDI and then you can move to PFL. Employees can choose to supplement these wage replacement benefits with like sick, vacation, PTO, such as during that first week of SDI while in the waiting period, or to cover a portion of the wages the state money does not cover. It's increased a lot this year. It's up to like 70, 90% of wages they replace. So that's great for them. You're responsible to inform the employee about the leaves. So that's your responsibility to inform them. But then it's up to them to apply. But once they do, ED may contact you to complete a form, like to verify dates and to show any wages that you paid during that time period. The key takeaway here is for you to be aware of these and understand they're solely money. They alone do not provide job protection. Okay, how to coordinate leaves. Now we'll tie all of those items together. A common scenario is a leave due to a new child. These can include 2 separate reasons for leave and all 5 categories we discussed. So when an employee is deemed disabled by pregnancy, the time counts as both FMLA and PDL, plus eligible for SDI payment. When an employee is no longer disabled, they move to bonding time, which counts towards any FMLA time they have left, and the CFRA clock starts. Plus, they're eligible for the paid family leave wage replacement. We have a couple examples for you with these visuals. In each example, the top row shows you how to code the protected leave. The bottom row shows you the associated wage replacement. So let's walk through these. Starting with the first example, the employee was out for 7 months straight. So she had all the time allotted to her. Her doctor indicated she was disabled by pregnancy for 4 months. So those first 12 weeks are protected under FMLA, and the full 4 months are protected under PDL. After a 1-week waiting period for the rest of the 4 months, she received the SDI partial wage replacement. So you can see there, we're just in that first little section, the dark blue, purple, the light green, that's where on the top left. Once she is no longer disabled, she chose to take the full 12 weeks of baby bonding. That whole 12 weeks is protected under CFRA. And for the first 8 weeks of that time, she received paid family leave, partial wage replacement. All right, so the only difference in the second example is the employee was only disabled for 8 weeks, which is more typical. That means her 12 weeks of FMLA is partially used during her disability, and the remainder is used during bonding time. Do want to mention one thing on the bonding time. They have the first year that the child is born to use that time. So it doesn't necessarily have to follow right after pregnancy disability. Like they might want to wait a few months, maybe wait till the kid's first birthday, but they have that whole year to use that, and they can split up the time somewhat. So coordinating all these different buckets is complex. So we can refer back to these visuals. Are benefits continued during leave? So this is a hot topic. Short answer is yes. So while on protected leave, you must continue to offer health benefits at the same level and under the same conditions as if the employee had not taken leave, which basically means the company continues their portion of the premiums and the employee is still responsible for their portion. You have options on how you collect those premiums, which you would need to apply consistently. So it's common to require the employee to mail in a personal check while they're out each month. Some companies choose to wait until they return, then collect them as premiums through payroll. Both have pros and cons. Whichever policy you set, you would need to make sure you make those arrangements up front with each employee as they're going on leave. Now, FMLA and CFRA regulations include an exception to allow you to cancel benefits the employee does not pay their premiums. However, the PDL regulation does not include that exception, which leaves it somewhat up to interpretation. I love those gray areas. Now, Cal Chambers' stance is that you cannot stop health benefits while on PDL just because they stop paying. So if you do decide to stop health coverage while on PDL, it's advised to check with legal counsel. Now, all of this is just on health benefits, such as medical, dental, vision, FSA. The regulation does not address non-health benefits. However, companies often choose to continue them. But since it's not a requirement to continue non-health benefits, it's advised to confirm with your insurance carrier on what they will allow. Last poll question. So if an employee's protected leave ends or they're not eligible for FMLA or CFRA, can we terminate them? So it's basically a yes, no, or maybe. Okay, let's see what we get. Okay, so you can see the answer on the screen there. So the answer is it depends. So a big maybe, a bunch of gray area. But we'll go over all of that on our next slide. What happens when protected leave ends? If the employee is ready to return to work, great. You make sure you return them to the same job or virtually identical position and reinstate any benefits if you stop them. But what if the employee needs more time? Or what if the employee is new and doesn't meet the requirements for FMLA and CFRA? That's where things are not as straightforward. So start with checking your internal policy because you want to make sure you're consistently handling these. Then if you want to allow unprotected time off, check with your carriers on benefits. Now, all of that, big disclaimer, is if they are disabled, then your work's not done. We have 2 additional laws that most of your companies will fall under. You can see the limits there. So Federal Americans with Disabilities Act, you just have 15 employees. But then California also has Fair Employment and Housing Act. That's all the way down to 5 employees. So with both of these, you need to follow the interactive process, which is just a fancy term for communicating with the employee and documenting. So in the process, the employee may request additional time off as an accommodation. As with any request, you need to determine what you can accommodate. If you determine a request would cause an undue hardship, we recommend consulting with an employment attorney before denying that request. We're in the home stretch. Documentation. These are the main types of documentation needed, but each leave type and situation may have different needs. The first 2 categories are published on government sites for you to download and provide to employees information. The last 3 need to be populated. So there's not a requirement for a specific form as long as the data is included. Now, both mineral and the government sites have templates, sample versions available for you to download. Okay, what resources are available? A great resource we offer free to all clients is the Mineral HR platform. They have a vast library of information plus forms and templates. They also have a webinar entitled Employee Leaves 101 that they host periodically. They also have a recording of that and the slides on their site. Plus, Mineral staffs a hotline with HR experts. You can call or submit questions in their portal. And the links here are a few of their resources to leaves. In addition, we provided links to government sites. And there's a lot on this slide, but another great reference to keep. Okay, that's all our content. You made it through. So we're going to bring on Angela, our internal HR director. Sarah's going to help us out by asking questions, and then Angela's going to jump in with answers. So let's see what we got.
All right, thanks, Kristen. That was great. Angela was busy in the back end answering some of these questions in the chat as well. But I'm going to address a couple of them that she didn't get to. There was a question, I believe, on the how to coordinate leave screen of what if the PDL is extended even longer past that designated time?
Hi, thank you. I'm just waiting for Sarah to.
Oh, sorry, Angela. You guys can't hear.
It's not, I'm disabled.
Let's get her on here.
We can hear you, Angela.
Okay. So I did see this question in the chat and I thought it was a great question. And what if the pregnancy disability leave is extended even longer? And while today's webinar is really about leave of absence, as you saw on Kristen's slides, there is that caveat, and I don't want to underestimate the caveat of the Americans with Disability Act or the California Fair Employment and Housing Act version of that, because your obligation does not usually end with a disabled person, whether they're disabled by pregnancy or anything else. If someone has exhausted their leave, pregnancy, FMLA, CFRA, any of those things, and they're disabled, it is in most cases going to behoove you to begin the interactive process versus jumping to some other step like, oh, leave is over, send a letter, you're done, that kind of thing. So if it is extended, then you do run into evaluating potentially additional leave as an accommodation to their disability. And that applies to all disability type leaves, whether it be that person's own medical condition, a pregnancy, anything of that nature.
All right, great. Another one that came in, when communicating leave approval to the employee in writing, both FMLA and CFRA must be mentioned in the letter, correct?
Yes, if you are covered under both of these entities, you do need to designate the leave and provide rights and responsibilities for both of these things. And depending on the set of documents that you're using, some people use Mineral, some people might use Cal Chamber, some people may create their own documents internally. But no matter what, if someone is eligible for both leaves, you are obligated to provide both the notices that you would provide to those employees, as well as the designation of leave to start that clock ticking.
All right. Another question here. They're asking to confirm, do FMLA and CFRA run concurrently?
Sometimes they do, and sometimes they don't. Most of the time, if the person is caring for another family member or maybe it's their own disability, those two things are going to run concurrent, except if a person is pregnant in the state of California, California says that because part of that CFRA is that baby bonding or child bonding, they say that while the person's disabled by pregnancy, they couldn't really bond with their child. So in that case, the CFRA gets stacked. And I think this is where can be some confusion because people think, oh my gosh, they just had all this FMLA, they're 12 weeks, and now you're telling me there's another 12 weeks? And the answer is yes. When an individual is disabled by pregnancy, those two split, but oftentimes they do run concurrent.
Great, thank you, Angela.
Mm-hmm.
Question about what about ending benefits? Even if additional leave is provided through accommodation, is the employer required to continue benefits?
And this is, again, there are so many factors that can go into this question. I know, Kristen, you covered some of them on your slides. As a general rule of thumb, while somebody is under your protected leave, whatever it is, you do want to continue the benefits for the most part. When it comes to ending them, it is often hard for an employer to know when that's the appropriate time. However, if you've gotten to that point where you're pretty sure you've fulfilled your legal obligation, you're like, okay, I've had all these benefits going for the entire FMLA period, the 12 weeks, and then you would want to consider putting them on COBRA, which is where they're still on your program. It's just that they're paying the premium. But there are certain stipulations. There's notices that you have to give in advance. And then also keeping in mind what your policy says, because your policy might say that they get benefits for the end of the month, that they're, even if they stopped mid-month, you might not get a prorate for that. So there are extenuating circumstances where you might pay those benefits beyond a protected leave. But most of the time, you're going to offer COBRA when that protection ends. And there are there's extenuating circumstances for non-payment, but that really gets into the nitty-gritty because it's different for each type of leave as to whether or not you would want to make that move. And if that's the case, you may want to reach out to our HR team.
All right. And then what is the obligation of the employer to stay in contact with someone who has been out on CFRA for months and you aren't sure if they're coming back, or only contact when leave is almost over? There seem to be a couple of questions about that uncertainty of somebody coming back after leave.
Okay, so that's a great question. When the employee goes out on leave and they make the request, if they tell you that they're coming back in good faith, then the employer just assumes that they're going to come back when they say they can or as soon as they can. And so you operate off that assumption, even though there may be times during the leave where it may be questionable because of the nature of the disability or other factors that could come into play where you suspect they may not be able to come back. But really, what you're operating off of is the facts of when are they due back and what does that doctor's note say? And so going back to the question of what type of contact is appropriate, that's really spelled out in the beginning when you're designating that leave. And it's also spelled out in the rights and responsibilities, which you give them that first 5 days, where it describes what time frames is the employee required to tell you, like, hey, I've got an extended leave request, or my doctor's requesting that I get additional time. It's sort of this back and forth. And so the employee may have to ask you to evaluate. And so there could be times where you're talking when things change, but otherwise, most of the communication happens before they go out on leave if they know it's happening, or if you don't know what's happening, as soon as they've gone out on leave, you've taken care of all your paperwork. And then most of the time you try not to bug the employee while they're on leave, and you just assume they're recovering and doing their thing and that they're going to follow those rights and responsibilities, and they're going to tell you if they need more time. Otherwise, you go off of what the leave request was for or what the most recent medical certification is. And I think a best practice is to reach out shortly before they're about ready to return, maybe a week before, and just to say, hey, just checking in, making sure everything's okay. And it's usually at that point when you're going to hear them say, oh gosh, you know what, I'm not cleared by my doctor yet. I really don't see them until whatever, another date. And so then you might adjust that return date ever so slightly, or perhaps if it's a child leave or something like that, a maternity leave, they may say, you know what, I changed my mind. I was only going to take 5 months, but now I want 6. So communication should be minimal and is necessary. And it's really per the guidelines of those rights and responsibilities.
All right. I do want to be respectful of time. We're at 10:31. We just have a couple questions left. So Kristen and Angela, if you're okay to stick around for a few minutes, anybody else is welcome to stay, and we'll bust these out. And again, we'll also send out some of these resources and questions in the recording. But let's power through the rest of them here.
Great.
So a clarifying question. Do I understand correctly that if there are only 4 employees, there is no obligation for leave under any of these programs?
So I would say if you only have 4 employees, then yes, you are not subject to CFRA or FMLA or the PDL, but I say that with a but because especially with pregnancy disability leave, if you were, before I denied that leave, I would consult with an attorney because I forgot if they call it, it's not common law, it's like shared law or community law or something where it's just because it's just assumed if someone's having a baby that you kind of need to let them go. So I would be cautious about denying someone if you have 4 employees a leave for the purpose of pregnancy disability, but you technically do not have a legal obligation.
All right, thank you.
Mhm.
Next one, how should an employer handle a situation where an employee is eligible for FMLA or CFRA leave, but declines to take it because they prefer unpaid leave in order to continue accruing PTO?
I love this question, and I'm glad you asked it. I wish everybody else could hear this because when an employee has a situation that qualifies for a leave, they don't really necessarily get to pick if it's designated as FMLA or CFRA or not, because it's important as the employer, you really want to start that clock ticking so that you know when you fulfilled your legal obligations. And now, there are times when this can't happen, like say, for example, an employee has plenty of PTO and sick time, and they go and have a secret surgery, and they don't tell you what they're doing. You don't know where they're going. Well, then you can't control that. But I do think if the employee is eligible and they say that they don't want it, I mean, it's unpaid. It can be unpaid no matter what. I mean, it's up to them if they want to apply for benefits or not. But it's still important for you as the employer to say, we know or reasonably should know that you qualify for this leave, and so we are placing you on leave. You can place someone on a leave and start that clock ticking if they're not at work. And then also the other pieces, because you don't want to have unplanned absences that are not approved. So if they want to continue accruing PTO, the way to do that is to use some PTO while they're out on leave. Now, they don't want to use too much because that could interfere with their benefits, but they could use a little bit of PTO and that would allow them to continue accruing if your policy allows that.
All right, thank you.
Mm-hmm.
Next, is the wage replacement calculation for SDI the same as for PFL?
Not exactly. To begin with, SDI does have a wait period of a week, whereas paid family leave does not. So right out of the gate, that is one huge difference. It's a full week more of benefits. Secondly, the PFL wage replacement is capped at 8 weeks versus the disability is much longer. Now, in terms of the actual calculation that they put into it, I do not have insight as to what those mathematical formulas are. And so I could not say with certainty if they are identical or not. But what I would advise is that if the employee is unsure, they can just go in and use either one of the wage calculators, and that will give them the answer.
All right. Can we offer them to continue to pay benefit premiums while they're on leave?
Yes, you can, and you probably should if that's your normal policy. I'd follow your policy, whatever that is. Every employer is going to have a different risk tolerance here. but you want to be consistent. And the most common thing to do is to collect that premium from the employee while they're out, whatever their share is. There are times where, like here at Morrison Garritano, we offer people to double up on their premiums when they come back. But not every employer would want to do that because obviously it would be hard to recover those if you, for some reason, did not receive those premiums. But yes, you can absolutely have them mail you a check.
All right. Are you guys all right to stick around for a little bit? Questions keep coming.
Yeah.
All right. If an employee has exhausted all FMLA and CFRA, you do the interactive process and they qualify for additional time off under the ADA, are you required to continue to hold their job, or are you just required to leave them on the books as an employee and then review any open positions that they qualify for upon return?
So if you are granting additional leave as an accommodation, they are still your employee. So once you make the decision that you're making that accommodation, it just means they're just still your employee. So that's not really it wouldn't be a separation. So, and then in terms of, are you required to hold their job? That is a business decision about whether or not you could reinstate them. But once you switch over into that ADA, it's not exactly the same reinstatement rights as FMLA and CFRA because the disability could morph or change and the ADA requests or needs could change. So that might involve different positions, different things. It really just depends on what the disability is that you're accommodating and what that looks like.
All right. Next one. Can you place a leave on employee? Can you place a leave on an employee due to domestic violence?
Yes. Domestic violence leave has had some enhancements this year, and that is absolutely a qualified leave. So if you have questions about how that applies, it's vast. And we did not cover that leave in this presentation because it's not one of the more common ones, but it is vast because it also covers not just the person experiencing the domestic violence, but it could be dependents of theirs experiencing domestic violence, and it also involves accommodation for domestic violence. So there's a lot wrapped up in there, and yes, it's a protected leave.
All right. Can someone on workers' compensation request an FMLA or CFRA leave?
Another $1 million question. I wish everybody heard this because workers' comp leave, if someone is injured on the job and they leave work, that is the same as if they just got injured any other way when it comes to FMLA or CFRA. And oftentimes, this is one of the areas where we see employers forget to designate either FMLA or CFRA for their own serious medical condition. But yes, absolutely, workers' comp leave and FMLA CFRA run concurrently.
All right. And they'll all hear that on the recording, so we're good to go there.
Okay, good.
All right, last one. Looks like when you receive a doctor's note that does not give a reason for the leave request under medical, when we send the WH-380 form that requests the medical provider to complete, what if they don't provide it?
So I would say when you first get that note that doesn't give a reason for the leave and the employee is requesting medical leave, then I would say that it depends on what else the note says. I mean, without seeing the actual note, it's hard to answer that question, but let's just say they just left it blank. They just didn't check any box or do anything. I would ask the employee to take that back to their doctor and have them specify how they're qualifying for the leave. You don't need to know what the medical condition is. You just need to know that it qualifies as a serious medical condition. And then likewise, the med cert from the WH-380, that official med cert and a doctor's note are interchangeable as long as the doctor's note contains the required elements. So you don't want to necessarily turn away a regular doctor's note. If it's incomplete, you can absolutely have that employee go back to their doctor and get clarification before you approve and designate.
All right. And I will mention a lot of these questions came in anonymously, but if you have a specific situation with an employee, feel free to call our office to talk to Kristen or Angela specifically, and they can give a little bit more detail.
Mhm.
All right, that's it.
Great.
Kristen,
Thank you.
wrap us up.
Okay. So thank you for that. Great questions. As a reminder, we will send you an email with a link to this recording and the slide deck. Give us a few days on that. But thank you for all those that attended live, plus all those reviewing this recording. Be on the lookout for communications on the next webinar in our HR in Half an Hour series. Thank you.